Hi everyone, welcome back to my session with respect to public international law. So in a previous session, we have discussed about the definitions of public international law, and in this session, we are going to discuss about the two theories that became the basis of the formation of international law. So this, when it comes for an essay, this has to be written along with the definitions we discussed earlier. That is with respect to Oppenheim, P. Corbett, Lord Coleridge and J.G. Stark. So the most appropriate definition in the modern era is the definition by J.G. Stark, which also considers and discusses about the non-state entities, individuals, and international organizations. So the nature of international law, or the theories of basis of international law, we have two theories here. That is, there is a particular group of people or propounders who says that international law is not a true law, and then there is another group who says that international law is a true law. So let's see who propounds that international law is not a true law. So this theory is propounded by John Austin, Hobbes, Holland, Pufendorf, and Bentham. So once again, John Austin, Hobbes, Holland, Pufendorf, and Bentham. These jurists or eminent jurists or people who did research and who propounded various doctrines and principles with respect to law. These people believe that international law is not a true law. Then there is yet another group who believes that international law is a true law, and who are the propounders of that theory, that is natural school of law. So we'll be discussing in detail about international law is not a true law. And we also have a very common question, short essay question that comes here, that is, public international law is the vanishing point of law. Explain or critically analyze. So that will also be discussed under this. International law is not a true law. And when you discuss about public international law is the vanishing point of law, that is because there is no international sovereign, there is no international legislation or international parliament. So these reasons also shall be mentioned. Now, with respect to the theory that international law is not a true law, Austin's view. According to Austin, law is a command of sovereign given by political superior to political inferiors. International law is not a true law, but a code of rules of conduct of moral force only. So, John Austin says that if something should be a law, it should be given by a sovereign who has command, and that sovereign is a political superior, and the command is given to political inferior. And this does not exist in the international scenario. And so what does Austin say is international law? So Austin says international law is not a true law, but it is only a code of rules of conduct, and that has only a moral force. Now, law in strict sense is the result of edicts issuing from a determinate sovereign legislative authority. This authority is politically superior if rules are not issued by a sovereign authority, or if there is no sovereign authority, then the rules are not legal rules. There will be only a moral force. Such rules are moral or ethical rules only. Therefore, international law is not a true law, but positive international morality. So what does Austin say? International law is not a true law, but a positive international morality. International laws are opinions or sentiments current among nations generally. So that is what Austin says, and this is with respect to international law is not a true law. Now, there is also John Austin, Hobbes, Holland, Pufendorf, and Bentham. They all agree with this point of view. There is no international sovereign, there is no international sanction, there is no international legislative body. So, international law cannot be considered a proper true law. And this is also the answer to the question that public international law is the vanishing point of law. Now, there is another theory that international law is a true law. So, who propounds this? It is propounded by natural school of law, and the chief propounders are Louis Henkin and Sir Henry Maine. So the chief proponents are Louis Henkin and Sir Henry Maine. According to Louis Henkin, generally all the nations observe the principles of international law and their obligations. According to him, objective of any law and its implementation is most important and not the means and methods. So what we have to note here is, for those who propound that international law is not a true law, they say it because there is no international legislative body, there is no international sovereign, there is no international sanction. So all these pertain to means and methods. So when it comes to international law, is a true law. Here what Louis Henkin states or points out is that international law is observed as a principle of international law, and that like all the nations observe the principles of international law and their obligation. So that is followed by every nation. So it shall be given the status of a true law. And further, according to Louis Henkin, objective of any law and its implementation is most important and not the means and methods. So that was said by Louis Henkin. Louis Henkin and Sir Henry Maine are the chief proponents of the theory that international law is a true law. Now, Sir Henry Maine considers that in primitive societies there was no sovereign political authority, yet there were laws. Austin's concept of law denied customary rules of international law and the status of law. Treaty and conventions are like legislations of international law. States do not deny the existence of international law. Some states like UK and USA treat international law as part of their laws. International law does not completely lack sanctions. Decisions of International Court of Justice are binding upon parties to the dispute. So one cannot say that there is no international sanction. So decision of International Court of Justice are binding upon the parties to the dispute. Now, you also have to consider the influence of natural law theory on the nature of the international law. So here, this theory says that ideal law founded on the nature of man as a reasonable being, the body of rules which nature dictates to human reasons, is law. States submitted to international law because their relations were regulated by the higher law, that is the law of nature. International law is a part of law of nature. Natural law contains those principles which natural law dictates to states. It is not less binding upon them than it is upon the individuals, because states are composed of men, their policies are determined by men, and the men are subject to the natural law. So international law should also be considered as a true law. So that theory is also based on the natural law theory. Now, theory of positivism on basis of international law. So international law has the same characters as municipal law. International laws are issued from the will of the state. International law can be reduced to a system of rules depending on their validity only on the fact that states have consented to them. For positivists, state is a metaphysical reality. It has a value and significance, and this significance makes a state to have will of its own, and this will is considered as the sovereign authority. So, by positivism school, the will of the state becomes the sovereign authority. International law consists of those rules which various state wills have accepted by a voluntary self-restriction. So, how have they shown their consent? By voluntary self-restriction. Without such manifestation of such consent, the international law would not be binding on the society of the states. Thus, international law is a branch of state law and external public law. Only for this reason they are binding on the states. Consent for the state may be expressed or implied. Now, Here, there is a view of Ancelotti that says that the agreements between the states are respected. That is pacta sunt servanda, and they create or they derive obligatory character from a fundamental norm. So that is with respect to the two theories that form the basis of international law, that is those who propound that international law is not a true law and those who propound that international law is a true law. So this is also the answer to the question that public international law is the vanishing point of law. So thank you for listening to me. I hope this helps. See you in the next session. Thank you. Have a good day. Bye.